Good afternoon. I'm Ilsa Knecht, and I'm the Deputy Director of Public Policy for the National Center for Victims of Crime. I want to welcome you to today's web seminar on collecting DNA from arrestees. A few housekeeping issues to go over before we get started. Today's audio is coming over your computer speakers, so this is a slide for people who are not hearing anything. Hopefully they can turn on and adjust the volume on their computer speakers so they can hear us. If you are having any technical issues during the webinar, you can use the question and answer box to request help from National Center staff, or you can call WebEx support at 866-229-3239. Everybody who is signed in today is in listen-only mode, which means that you will not be able to ask a question verbally, but you can use the question and answer box to send a question to the host or to the panelists. We will be answering questions at the end of the webinar, so we'll allow a few minutes for that, or if we don't get to your question today, we'll follow up with you by email, or you're welcome to email the presenters directly if you don't get an answer today. This is what the Q&A box looks like. So you just type your question in the box underneath the all panelists or all participants. You can send it also directly to the host if you want to. Don't forget to press send. That sends the question to us. And the questions are not seen by other attendees usually, but today I'm not entirely sure because it says you can send to all participants. So just be aware that some other people may see what you are writing. I want to take a minute to tell you a little bit about the National Center's DNA Resource Center before I turn hosting over to our presenter today. The National Center's DNA Resource Center's goal is to increase understanding about how we can solve more crime and prevent more crime by increasing the use of forensic DNA and DNA databases. I want to thank our sponsor, who's Life Technologies, who supported our work in this area for quite a long time. And with their support, we have conducted many webinars, trainings across the country. We've developed materials about forensic DNA for victims, for victim advocates and law enforcement professionals who work with victims. This is our website, victimsofcrime.org/DNA. You'll find archived webinars there. We have over 18 now on various topics such as taking DNA upon arrest, sexual assault kit backlogs, local DNA databases, close match and familial searching, and in the future we'll be doing some more work on rapid DNA. We also have information about using DNA in burglary cases and in missing persons and trafficking cases as well. So you can visit our website there for those archived webinars. We also have news, statutes, and legislation related to DNA, and sample victim notification policies for working with victims in cold cases. This is my contact information if you want to email me with any questions or just tell us how we're doing. If you have any news to share with us, we'd like to hear it, and we also are on Twitter. It's not here, actually. It's just at DNA Answers. Our Twitter account. Okay, I'm going to go on to our main event now. Excuse me. We are thrilled to have Senator Debbie Smith from Nevada today and Jayann Sepich of DNASaves.org. Debbie Smith has lived in Nevada most of her life. She was elected to the Nevada Assembly in 2000, where she rounded out her service as, excuse me, my throat. I got something in my throat, sorry. As Speaker pro tempore. In 2012, she was elected to the Nevada Senate and serves as an Assistant Majority Leader and Chairman of the Senate Finance Committee. In the 2013 legislative session, Debbie championed Brianas Law that requires a DNA sample for those arrested for felony crimes. In 2013, Senator Smith was elected President-elect of the National Conference of State Legislatures and will assume the presidency in 2014. Jayann Sepich is a mother, homicide survivor, and advocate whose daughter Katie was brutally raped and murdered. Since that time, Ms. Sepich and her family have traveled the country and the world to ensure that all 50 states pass legislation to mandate DNA testing upon felony arrest, also known as Katie's Law. She has been honored by Governor Bill Richardson of New Mexico as an outstanding New Mexico woman and was inducted into the New Mexico Women's Hall of Fame. Ms. Sepich and her husband co-founded DNA Saves to educate policymakers and the public about the value of forensic DNA. She is a very powerful force to be reckoned with, and we are really thrilled to have her with us today to talk about the power of DNA upon arrest laws. So I want to welcome Jayann. And Jayann is now, are you there, Jayann?
Yes, I am.
Oh, good. Okay. Sorry, I had a problem with the unmuting. All right, you have the floor. Thank you.
Okay. I want to say hello to everyone, and I want to say thank you so much for joining this webinar today to learn more about the power of arrestee DNA testing to not only solve crimes, but to prevent crimes, save lives, and exonerate the innocent. My name is Jayann Sepich, and 10 years ago, I only thought about DNA when I watched television crime shows or sometimes when I heard news about crime, but for me, all that changed on Labor Day 2003. Up until then, I'd lived a quiet and eventful small-town life. I was married to my high school sweetheart, Dave. We have 3 children, and at that time, it was our 9-year-old, Caroline, our son, AJ, who had just graduated with honors from high school and started college at the University of New Mexico, and our oldest, Katie, who was a 22-year-old graduate student working on her Master's of Business Administration. On that Sunday of Labor Day weekend, we were getting ready for a backyard cookout with all of our friends, and then at 2:15 in the afternoon, the phone rang, and our lives were shattered with just 6 words: "Have you talked to Katie today?" It was Katie's roommate, Tracy, on the phone. She and Katie had gone to a friend's house the night before, and Katie had argued with her boyfriend and decided to walk home. She was furious. She stormed out without her keys, her purse, her phone, and no one had seen her since. Tracy had called all of Katie's friends and even the local hospitals, and Katie had simply vanished. We told Tracy to file a missing persons report. Katie's dad, Dave, headed out for Katie's college town, Las Cruces, New Mexico, 4 hours away to look for her. When Dave got to Katie's house, he was met by the county sheriff, a chaplain, and a victim advocate. When Tracy had reported Katie missing, the authorities knew that the body that had been found that morning in an old garbage dump was most probably Katie. Dave had to go to the morgue and identify his daughter. She had been viciously raped, beaten, sodomized, strangled, and set on fire. Now, over 10 years later, I still can't describe to you the pain. It's just excruciating. In one moment, all light, all hope is gone. It hurts too much to take one more breath. But the sun comes up the next day, and through the grief and sorrow, there are so many questions. Who could have done this? Why? We needed answers. We needed justice. And most of all, we needed to know that this man would be stopped from doing this again. There was very little evidence, almost no clues, but Katie fought so hard for her life that underneath her fingernails was the skin and blood of her killer. The detective in charge of her case told us that a DNA profile had been extracted from that tissue and uploaded into the National Forensic DNA Database called CODIS. He went on to explain that once a week they would cross-reference this evidence against the offender database to look for a match, and this gave us bright hope because we knew we had the identity of Katie's killer. We only had to match it to a name. And I made the offhand comment that this man was such a monster that surely he would be arrested for something else, and we would identify him. And that's when Captain Jones said, "Oh no, Jayann, it's illegal in New Mexico and almost every other state to take a DNA sample when someone is arrested. We have to wait until they are convicted of a felony." I couldn't believe it. I was stunned. I knew that fingerprints and photographs were taken at the time of arrest. I knew enough about DNA to know how accurate and reliable it is, and I simply couldn't believe it was illegal to take DNA at the time of arrest. So I started doing research, and I started asking questions. Why is it against the law? How does the CODIS system really work? Why aren't we using DNA in the criminal justice system just like fingerprints? When I began speaking with legislators, some told me that since DNA contains our genetic blueprint, It's more of an invasion of privacy than fingerprints to take our DNA and put it into a database, especially before a conviction. I'm not a scientist. I had very little true scientific knowledge of DNA, so I tried to read and learn all that I could. And then I contacted experts in forensic genetics and asked them to please explain it to me in a manner that I could understand. That's when I learned that it is not our DNA that goes into CODIS. It is a DNA profile. And there's a huge difference between our DNA and a DNA profile. I learned that our DNA, the human genome, contains over 3 billion base pairs or markers that make up our genetic code. But our DNA profile has only 13 of these pairs. And 12 of these 13 markers were chosen specifically by genetic scientists because they are non-coding. They have no genetic or private information. One of the 13 markers does denote gender. But other than gender, the DNA profile in the database has no ability to disclose any private or medical information. I learned that this is the information that actually goes into CODIS. That's what's there. There's a lab identifier, the originating lab that did the original analysis. There's a specimen ID number, which automatically generated upon entry. Then there are the 13 markers. There are 26 numbers that identify those markers, and there's the initials of the lab analyst. That's it. That's all. There are no names or Social Security numbers in CODIS, only a specimen ID number that is randomly generated when the profile is entered into CODIS. And that is only matched back to a name after there is a direct match to crime scene evidence. So here's the numbers that were on that profile. And those are my markers. I had my DNA profile done, and that's me. So if you want to take out a pen and paper and write down these numbers, feel free. There's nothing that can be disclosed by those numbers, and I'm so certain of that I have my DNA profile printed on the back of my business card. Now, I don't have my Social Security number on my business card or even my home address, but my DNA profile is there. I hand it out to everyone. It's also a federal offense to tamper with CODIS, and since the inception of CODIS in the 1990s, there has never been a misuse or a breach of the database. I also learned that there are many studies that have been done to show how taking DNA at the time of arrest can actually prevent crimes. One such study done by the City of Chicago followed 8 convicted felons and found that had their DNA been taken at the time of their first felony arrest, 60 violent crimes, including 53 rapes and murders, could have been prevented. Prevented, not just solved, prevented from happening. But it was when I stumbled across the case of Chester Dwayne Turner in California that I knew the true power of taking DNA at the time of arrest. You see, Chester Turner was arrested 21 times over a period of 15 years without ever being convicted of a crime that would allow his DNA to be taken. When he was finally convicted of rape and his DNA taken, it was found on 12 raped and murder victims, his DNA profile. His first victim was murdered 2 months after his first felony arrest. Her name was Diane Johnson, and he went on to murder Annette Ernest, Anita Fishman, Regina Washington, Deborah Williams, Mary Edwards, Andrea Triplett, Desiree Jones, Natalie Price, Mildred Beasley, Paula Vance, and Brenda Breeze. These aren't names. These are daughters. These women have mothers who buried them. And it was at that moment that I knew that the laws had to be changed, that there were so many lives to be saved, so much pain to be prevented, fathers that wouldn't have to identify their daughters in a morgue, mothers that wouldn't have to leave their babies to be buried, and brothers and sisters that wouldn't lose their best friend. If Turner's DNA had been taken after his first felony arrest, it is probable that 11 of these women would still be alive. He could have been stopped after the first murder. And to make it worse, a man named David Jones had been wrongfully convicted of 2 of these murders and had spent 11 years in prison. When they got the DNA match from Chester Turner to these murders, David Jones was released from prison. But what could we have done if we had had arrestee DNA? One DNA sample, one cheek swab, 11 lives spared, and prevented an innocent man from spending 11 years in prison. After learning of how CODIS is designed to protect privacy, after learning how taking DNA upon arrest would save innocent lives, our family decided that we had to do what we could do to see legislation passed, allowing DNA to be taken upon felony arrest. We started in our home state of New Mexico. We went to our legislator and explained the situation and asked that he introduce a bill in the New Mexico State Legislature, and he did. Katie's Law passed and was signed into law by Governor Bill Richardson in March of 2006. Our law in New Mexico went into effect midnight, January 1st, 2007. 1 hour and 14 minutes after it went into effect at 1:14 a.m., the first felony arrestee was swabbed under Katie's Law, and his DNA matched a double homicide, and he has since been convicted of both of those murders. Since that time, in New Mexico, 514 cases have been matched to 463 felony arrestees. This is in a state with a population of about 2 million, and it's working. It's working to identify predators earlier, which means crimes are prevented and lives are saved. Passing Katie's Law in New Mexico was important to my family, but we realized it was just a first step because New Mexico was only the 6th state to mandate taking DNA at the time of arrest. That meant 44 states didn't have it, so we decided to keep going. We really didn't know what to do, but we just decided to send out letters. So in November of 2006, we sent out letters to every state legislator in those 44 states, telling our story and asking that they consider passing a law in their state. And many responded asking for information so they could begin the process in their states. So our family embarked on our new mission in life, seeing all 50 states pass and implement legislation to take DNA upon felony arrest. Then on December 18th, 2006, a miraculous event happened in our lives. We received a phone call from the officer in charge of our daughter's murder case saying that they had a DNA match. You see, my daughter was murdered on August 31st, 2003, and a man named Gabriel Avila was arrested in November 2003 for burglary, but we didn't have an arrestee DNA law in New Mexico, so his DNA was not taken. It was over 3 years later he was finally convicted of a felony, an unrelated felony, and he was incarcerated. His DNA was taken, and his profile matched the skin and blood evidence that was found under Katie's fingernails. Armed with this DNA match, the detectives began an intensive investigation. The ring that Katie was wearing the night she was murdered was found in his vehicle. The tire tracks that were found by her body matched the tires that were on his vehicle. Faced with this evidence in the DNA match, Gabriel Avila confessed. On December 26, 2006, he was formally charged with the rape and murder of Katie, and ironically, on that day, Katie would have been 26 years old. In May of 2007, Gabriel Avila was sentenced to 69 years without the possibility of parole. During over 3 years of intensive investigation, Gabriel Avila's name had never surfaced at any time. He was never a person of interest. No one ever even mentioned him. Without that DNA match, it is probable that Gabriel Avila would have never been identified, never faced justice for murdering our daughter, perhaps never have been stopped. That's the power of DNA. But the lesson to be learned here is the power of arrestee DNA. You see, if Katie's Law had been in effect, if we could take DNA upon arrest, when Gabriel Avila was arrested in November of 2003 for the unrelated burglary, we would have identified him 3 years sooner. He could have been stopped 3 years sooner. It is so very important that we analyze rape kits. We support this. We think that's very important. But if you don't have the offender profile in the database, you can't have a match. So we need to get those offender profiles in the database sooner. In December of 2008, our family established DNA Saves, our nonprofit organization, to help pass laws for DNA upon arrest, and we've continued to work with state legislators, and now 27 states and the federal government have arrestee DNA laws. These are the states that have passed an arrestee DNA law, and if your state's not there, you need it. You need that law because it's working. Virginia has had over 800 matches to their arrestee DNA database. Colorado had 40 matches in the first 4 months that their system was in place, and 9 of those were to cold case rapes. California is seeing an average of 10 matches per day to their database. And we've also learned that taking DNA at the time of arrest saves taxpayer dollars. There have been a number of studies that reflect this. The most recent was a study done by the University of Virginia. And what that found is that for every DNA profile that is put into the database, which costs about $30, every one of those profiles saves taxpayers $27,000. There are costs involved in initiating an arrestee DNA program. And in 2008, our nation experienced the economic crisis, which meant that states' budgets were just decimated. So we went to the United States Congress to ask the federal government to carve out grants that would help states to pay to implement DNA programs. On December 28, 2012, Congress passed the Jayann Sepich Expanded DNA Collection Act by an overwhelming majority. It was signed by President Obama in January of this year. As a result, states are eligible for significant grants to help them set up DNA arrestee programs, and these grants will be available through 2015. Another thing that we have faced is the question of whether or not arrestee DNA testing is constitutional. Some have said that it was a violation of the Fourth Amendment of our Constitution, which protects us from unreasonable search and seizure. There have been court challenges to arrestee DNA programs. Our nonprofit organization, DNA Saves, submitted legal briefs called amicus briefs in 5 of these court challenges, and I always believed that eventually one of these cases would make its way to the United States Supreme Court. In February of this year, the United States Supreme Court heard oral arguments in Maryland v. King. Our family traveled to Washington, D.C. to be present for those arguments, and it was an incredible experience. And we were very gratified to hear Justice Alito say that this case was perhaps the most important criminal procedure case this court has heard in decades. And then on June 3rd, the United States Supreme Court ruled that arrestee DNA is constitutional, that it does not violate the Fourth Amendment, stating that DNA, like fingerprinting and photographing, is a legitimate police booking procedure that is reasonable under the Fourth Amendment. We're absolutely jubilant about the positive Supreme Court ruling, but there is so much work to be done. 23 more states that need to pass legislation. We know when a state chooses to pass and implement an arrestee DNA testing program that lives will be saved. We'll never know the names or the faces of those who will be saved. We'll never have the chance to meet those families who will be spared the pain and trauma of losing a much-loved child. But we do know that all across this country are those who will be spared. I always think of these 11 women in California that could have been saved through arrestee DNA. And the same is true for each and every state in our nation. Because when a state fails to fully use the power of arrestee DNA, in the months and years to come, there will exist a list of new names. We'll know their names. We'll know their faces. We'll know the stories of those who could have been saved. We will look back and say, if DNA had been taken when that perpetrator was arrested, these lives could have been saved. We'll know who they are, and their mothers and their fathers and their sisters and brothers will know that they could have been spared the agony of burying their loved one. And I believe that's a heavy burden that we all bear, because through arrestee DNA testing, that agony can be prevented, and families like ours can be spared the agonizing pain that we have lived. Thank you so much for your time and attention today. Passing arrestee DNA testing legislation is not easy. And you're going to hear now from State Senator Debbie Smith of Nevada, who took on that challenge as a sponsor and champion this year of Brianas Law, named after Brianna Dennison, who was raped and murdered in Reno in 2008. And she's got it passed in Nevada. It takes courage and it takes passion, but the result is knowing that lives that otherwise that would be lost will be saved. It matters. Thank you, and here's my contact information if you would like to contact me. And now I know that we're all very honored to hear from Senator Debbie Smith.
Well, good morning and good afternoon, depending on what part of the country you're in. This is Debbie Smith, and I'm really happy to be on this call. You know, as we've gone through this journey with arrestee DNA in Nevada, it has been, I can assure you, one of the most significant things I've done in my time in the Nevada legislature. I served 10 years in the Assembly and just finished my first session in the Nevada Senate. We first had legislation in our 2011 legislative session in Nevada, and it passed my house at the time when I was in the Assembly overwhelmingly, but did not pass the Senate. It wasn't brought up for a final vote. Even though we believed we had the votes, it didn't get brought up, and so we went back after it for the 2013 legislative session. And I'd like to talk to you about what we did differently and how we did that to pass this bill. I want to start by, you can see the slide of making the case. And, you know, these two beautiful young women are what led me to becoming a passionate advocate for arrestee DNA. And in kind of a coincidence, I live in Reno, Nevada, and Brianna Dennison was murdered here in 2008. And while there was DNA left at the scene of her murder, there was no match found. And in fact, in the beginning of the case, there was a backlog of DNA in Washoe County, and we actually collected contributions from private sources in the community to pay to run that backlog, and still didn't have any luck. So that case proceeding, and then I went to an NCSL, National Conference of State Legislatures meeting in Philadelphia in 2009, and I had received multiple requests to come to a DNA Saved luncheon that was hosted by the Sepich family. And I went and listened and became instantly intrigued by the concept of arrestee DNA. I had not been involved with much criminal justice legislation and had not spent time on this issue, but these two cases came together for me, and I became very interested in working in Nevada to promote the legislation. So as I said, we ran the legislation in 2011, and then we went back to it in the 2013 session, which we've just come out of. You can see on the slide here, the Senate Bill number 243, and the legislative website where you can access the language and the bill history for Senate Bill 243. We had a very different experience in this legislative session, and I'm a complete believer that the reason we had a different experience is because we went about it in a different way, and we were so ready for the 2013 session and had so many people working together and on board that our experience was different. So first I want to just walk you through the primary provisions of Senate Bill 243 so you can see what the bill is about, and you can certainly go to our website and print a copy of the bill and the whole history and see the details. As I'm sure most listeners know, DNA legislation is extremely complex, and that's one of the challenges to promoting the legislation is making sure you get the technical aspects of the bill right so that issues there don't end up sidelining the bill rather than having the bigger discussion about the value of arrestee DNA. So I don't need to read this to any of you. You can see for yourself that the basic idea of Senate Bill 243 is providing for being able to take arrestee DNA when someone is arrested for a felony in Nevada, and then putting it into the CODIS system. We went through a lot of work in the second bullet that you're seeing on this slide now regarding purging records and allowing people to have their names taken from the CODIS system if they are not ultimately charged or convicted, and there's a lot of detail involved in that, which you can see if you go to the website and look at the legislation. And then finally, one of the important provisions in our legislation that we worked through, this was not in what we presented at the beginning of session, but we worked through this during the session, is creating a subcommittee within one of our interim committees on the administration of justice that will keep an eye on how the DNA, arrestee DNA legislation is implemented, and then how it works. There was some concerns, of course, about profiling, which we always are mindful of, and so this subcommittee will have a chance to review the implementation of the legislation and basically keep an eye and be able to report back to us on how it was implemented and how it was utilized. I really want to be able to spend my time talking to you here about what we did differently that made us successful with our legislation, and planning was clearly important in this. As soon as we left the 2011 session, in Nevada we only meet every other year, which certainly gave us more time, but you know, those of us who advocated on the bill regrouped and decided that yes, we did want to put in a bill again for the next session, and we started instantly bringing a small working group together that included, we had a pro bono lobbyist who had worked with us in the previous session. We had the Dennison family. We had Jayann helping us from afar, and then sometimes coming to the state. We had our lab technicians, the directors of both of our forensic labs, the main labs in Nevada. We had law enforcement, so that we had every point of view involved in this, and then we had our Legislative Counsel Bureau staff involved, so that we were looking at all the technical aspects of the bill and trying to draft appropriately as we went forward. And we really ended up with some very good language. The lab directors suggested that we take the model legislation for DNA labs and incorporate that. We did incorporate most of it, and it made for a very clean bill. And then we just stepped through all of the prior testimony and the concerns, and we brought those together so that we felt that we were addressing any of the stumbling blocks that we had in the previous session. Early intervention is obviously what I've been talking about, that I think on a bill that is this complicated and also emotional and passionate. There's a lot of stories around the legislation, as you've heard from Jayann, as we heard from the Dennison family. So there's a lot of passion around it. So it really is important to plan early and have all of those people involved from different points of view. The education piece, I think, is clearly what made a difference for us, and this is what I want to really spend some time talking about. The first thing we did when we did the bill is, you see there's a bullet there about bipartisan outreaches. I had myself as the prime sponsor as a Democrat in the Senate. I solicited the Republican minority leader in the House to be the co-sponsor for me, and the two of us alone had our names in that bill and proceeded with that. And then what we started doing during the actual campaign season is identifying viable candidates who were running for office We started educating them as early as we could. We started going back to the legislators who had been in the legislature before and were familiar with the bill, but perhaps maybe had some misconceptions or some misunderstandings about arrestee DNA. We re-educated them. We came up with a packet of information that we gave to all legislators. We produced a Mythbusters sheet that kind of stepped through some of the common misunderstandings about arrestee DNA or DNA itself, how DNA is processed, how the CODIS system works, security, all of those issues, and we used that a lot with our candidates. The other important thing that we did is we set up tours where we invited all of our, as soon as the election was over, we invited all of our legislators to come to visit one of the forensic labs in either Reno or Las Vegas. They could take a tour of the lab. They could see for themselves how secure it is. They could ask any questions about how DNA is gathered and how it's processed. And then we had a presentation for them about DNA, about CODIS, so that they had the scientists there who actually do the work every day, answering their questions and informing about how the DNA works. That was hugely successful. At the end of the day, we actually turned some no votes from the previous session around, and part of it, I think, was because they had that hands-on opportunity to go into the lab and have these opportunities and have their questions answered. And I can tell you that there's so much misunderstanding out there that having that educational opportunity is critical to getting this done. You know, I want to talk about counting votes, which is the final bullet in this discussion, that every step of the way we were counting our votes. We had a vote sheet going out of the 2011 session, and of course it was a little easier for us because we had done this once and we did have some votes out there, but whether you're doing it the first time or whether you're doing it the second time, starting that vote sheet early on and keeping close track of your yeses and your nos and your maybes is critically important. Every step of the way, we were counting votes. Every meeting we had, we were going over who was yes, who was no, who was maybe. And the important thing on vote counting is, as you may know or not know, is sometimes as the other side starts lobbying on this, you know, you can see some of your votes either softening or going away. So the vote count was really, really important to us, that we knew every step of the way, you know, who was solid, who was a solid no, and then who was squishy, as I like to say. That really led our whole process from beginning to end. We entered the 2013 session much more prepared. Our bill was ready to go. It was clean and had a lot of buy-in. So we went through our presentation process. Jayann came and did a great job, as she always does, telling her story. We had the denizens come and talk about their story with Brianna. You know, it was clear that there would have been a possibility had arrestee DNA been in place when the man who was ultimately arrested and convicted for murdering Brianna, he had been arrested previously, and had DNA been taken then, they possibly would have caught him sooner. He did rape other women, and so some of this could have been prevented with arrestee DNA legislation. So those stories were very important, and the passion around those was very important, but also having the experts there who could talk about DNA, who could talk about how the labs work in these hearings was critically important. We had a very long hearing initially in the Senate. It was very powerful and very successful. It basically took up our entire morning in the Senate Judiciary Committee. Ultimately, and much to my surprise, this bill passed our Senate unanimously. We had to have a 2/3 vote because we have a 2/3 requirement in Nevada that any bill that increases a fee or raises a tax needs a 2/3 vote. And so you can imagine that was one more layer of difficulty for us, making sure we could get to 2/3. that's one of the important things about DNA legislation is that it's not a partisan issue. You will find people supporting or not supporting for a variety of reasons that don't have much to do with party politics. It's a very bipartisan or nonpartisan effort. We had our governor on board, which was very helpful because we knew that when the bill got to him, he would sign it. So it passed our Senate unanimously. It sort of became like a freight train running, and once it hit the Senate floor, you could clearly see that the couple of people who we thought would vote no just couldn't vote no because it was so powerful. We took it over to the Assembly and went through the same process. We had a very heavy lobby by the ACLU going on. And so we had a little heavier lift when we got to the Assembly. The Assembly is very much more democratic, and we had some heavy lifting to do there. Ultimately, that bill did pass with a 2/3 vote in the Assembly as well, and we went on to have the governor sign the bill and actually had it out of the Senate the middle of May, which was nice before some of the sometimes difficult bills, start being held hostage. And then a couple of days before our session was over, on a very exciting day, the Supreme Court ruled. And so before we left session, we knew that our bill would stand and that it was ready to be implemented. I'll go back and touch just briefly on the fee because we really thought in 2011 for sure that the fiscal side of this would be what really held us up rather than the technical merits or the constitutional merits. But we put on a fee, which you can see in the bill, on any court cases, and that's how we're raising the money. And we have a 1-year implementation period, so it allows the counties and the DNA labs to access those court fees in time to build up their resources so that in the second year they can actually start taking and running the DNA upon felony arrest. So that's been our story in Nevada. It's been very gratifying along the lines of what Justice Alito said. We've had legislators say that they think this was the most important bill we passed in this legislative session, that this will be the biggest criminal justice legislation to come down in our state in a long time. And I think it is significant. I think it's going to save us money. It's going to put bad people in prison, and it's going to prevent crime. And that's why I am such an advocate, because you can go back and look at the most recent study out of the University of Virginia and clearly see that this is a crime prevention tool as well as a cost-saving tool in the criminal justice world. So I thank you for your attention today. I'm happy to help any way I can in your state. If you're interested in this legislation, I will talk to you. If possible, I'll come to your state. I'm such a believer and want to help what we can do to grow this legislation across the country. And thank you again.
Thank you so much, Debbie, Senator Smith. We have a couple of questions. Do you have time to hang out for just about 5 to 10 minutes?
Absolutely.
Answer some questions? Okay. All right, this is one I have never heard of. Has the 2008 passing of the Genetic Information Non-Discrimination Act helped in quelling some of the general fear in the use of DNA? Have you heard of that?
I can answer
Jayann?
that. This is
Jayann
Sepich. Yes, I'm very familiar with it, and it is helpful that we do have that. We do have that federal legislation. That is helpful. Unfortunately, there are people who still, are afraid of the privacy issues, and it's just very important that they understand how that database works and what that DNA profile actually contains. And I think that's been as important, or maybe even more important, than the federal legislation, which prohibits genetic material being used in hiring or in insurance or that kind of thing. But it's a wonderful thing that did pass and that we do have that.
And if I may add to that, this is where it goes back to education, that it is so important that people know what laws are already in place, that they know that the CODIS system has never had a security breach. That's that whole education piece that can be done with your forensic labs that can make such a big difference.
Right. We at the National Center, we did a survey in 2008 and again last year, and we asked some basic questions about DNA. We had over 1,000 respondents, and we found that there's a lot of misinformation about just about DNA generally. People, understand that DNA tells us all kinds of things about our, ourselves and our bodies, but they didn't understand that the profile created for CODIS or for the DNA database doesn't tell you, doesn't tell you your HIV status, for instance, or your race, or genetic abnormalities. And that when you could get past those and explain that to people, sort of, and Jayann went through with you today, a lot of that, you'd have more on your driver's license than you do in a CODIS profile. We can kind of get past that.
We talked a lot in the Nevada legislature, too, about thinking about what someone goes through if they're arrested. Aside from DNA, fingerprints are taken, and fingerprints are never destroyed. There's not a way to destroy them. We have, in probably any office, including teacher licensure offices, you have fingerprint cards sitting around all over states. You have the mug shots of people on the front page of the paper. When you're arrested, they can take your phone and go through your phone, which is very personal. They can explore bodily cavities looking for evidence. So having that perspective on the privacy side of all of the other things that are currently being done, I think really does help. And the idea that, that DNA is an amazing scientific tool that's much more accurate than anything else, and it is much more private and secure than anything else.
Right, exactly. Maybe both of you can talk a little bit about the CODIS laws. There was a question about whether or not somebody that's not convicted of a crime can have their profile entered into the national database. So there's different laws per state, but maybe you can talk a little bit about the state versus federal.
I can answer that.
Yeah.
In 2006, the federal law was signed that allows arrestee DNA to go into INDIS, the national database of CODIS, only if the individual state allows it. So the state law has to be passed, but then, yes, it can go into INDIS to the national database. There is a requirement that if arrestee DNA is allowed to go into the national database, the state must have some provision for expungement if the person is found not guilty for any reason for the crime for which they were arrested. So that is a federal requirement. So every state, has to have the provision allowing for expungement. Also, in order to get the federal grant money under the Sepich Expanded DNA Collection Act, states must notify the arrestee that when they are arrested that they are eligible for expungement if for any reason they're not found guilty of the crime for which they're arrested, and it must notify them in writing of the procedure that has to be followed, and that has to be available on a public website. But yes, it's absolutely legal to put arrestee DNA into the national database.
Thank you.
And let me add that that's one of those maybe myths or some of the testimony that we had to combat in the Nevada legislation was, there were some people who did not believe that you could actually expunge DNA from CODIS, and so it's important that those things are clearly identified and clarified for your legislators.
And not only is it possible, but it's audited. And there are periodic random audits and also just periodic annual audits that every state goes through to make sure that anyone that is eligible for expungement has been fully and completely expunged out of the system. And those audits are available for public viewing, the audits, to make sure that it's been done correctly.
Okay. Thank you for that. That's very helpful. We have one more question, it looks like. The question is, does person include all ages or 18 and older? That's a little bit of background here, saying that in the state of Nevada, fingerprinting and photography of a juvenile must be 14 to 18 years old, and under age 14 must have a search warrant. So you could talk about
every state has a different law concerning juveniles, and so the state law is what determines what can go into INDIS and what determines what goes into their state code system. I do know in New Mexico that the law only applies to those 18 and over. 18 and under, they do not take a DNA sample upon arrest, but every state is different. And I do know that as we go through this process state to state, that is always a discussion, and always, you know, every state looks at that differently. But if the state allows it, then it can go into INDIS.
Okay. Let's see. Oh, well, here's a good question. This is a good one for closing. But Jayann and Senator Smith, do you have anything you want to add as a closing thought or statement?
Well, one of the things I would like to say is that I do travel, and I do go to states, and I do testify, and I do sit down and talk to individual legislators and other stakeholders, and just contact me. This is our family's passion. This is what we feel is very important. So, that's why I had my contact information there, because we certainly want to help.
I can tell you already. Oh, go ahead. I'm sorry.
I was just going to say, this is Senator Smith. I would agree with Jayann, and if your state is interested, we can even arrange to come at the same time, because we've sort of done this hand in hand in Nevada. And the support from Jayann's organization was hugely helpful to us as we moved forward, because we had that big resource of information to rely on. But it's been, as I said, a tremendous experience, and I would share it with anyone and would be happy to help any state work on this, because I think it is significantly important in our legislative work when we're talking about, crime prevention and the cost of crime as well.
I can tell you already that we have one person who's asked for for us to come to their state, so we'll be following up with that person a little bit later today. I really want to thank Senator Smith for taking the time out to be here and to talk about this issue, and I'm really inspired by your work and how dedicated you are to this, and so it was really wonderful to have you come and talk about this issue from a legislator's perspective. Jayann as well, your story is always amazing, and I hope that we can get you out there to all the states that you listed that don't have this law, because we are very dedicated to passing this law in all 50 states, so that we can prevent crime and solve crime. So anybody, just feel free to, here's my contact information. I can get you in touch with Jayann or Senator Smith. We are, again, here's our Twitter account information and our website for the DNA Resource Center. The PowerPoint and a recording of the session today will be available online in a couple of days, so you can go to this the DNA Answers or the DNA Resource Center website and see the other archived webinars as well as this one. I think that's it. We don't seem to have any more questions, and I want to thank everyone for being here, and to our speakers, and to have a really wonderful afternoon.
Thank you.
Thank you for your time and attention. I really appreciate it.
Nope, I'm good.